let's talk about proving liability under the Jones Act. And keep in mind, as we talk about this subject, remember that workers' compensation, a no-fault system, is much different from the Jones Act, a federal statute. So when we talk about your neighbor who works in the auto factory or someone who works in the grocery store, they're entitled to workers' compensation under the state law of your particular state. The Jones Act is different. It is a federal statute, and in order for you to basically receive $1 of damages, you have to prove liability on behalf of your employer. So when we talk about liability, we're talking about someone that you work with either causing or contributing to cause a condition or your injury in a negligent way. For instance, if you're out on a deck working and your fellow deckhand does something that contributes to your injury, that is negligence. If you are out working and there's grease on the deck, that is an unseaworthiness condition of the vessel that caused you to slip and fall and get injured. On the other hand, there are other conditions, like for instance, perhaps you were working shorthanded or in inclement weather when you should not have been working. So those are all conditions that or situations that you're required to prove in order to basically show liability on behalf of your employer. So under the Jones Act, you have to first show that the employer contributed to cause your accident in a negligent manner. Once they do, then if that negligence causes injury, then you're entitled to damages under the Jones Act. So that's one important factor to remember, that you must prove liability on behalf of yourself against the employer under the Jones Act.